Good evening. We begin tonight with breaking news. We have obtained what is expected to be a central piece of the government's case against Donald Trump. The actual audio recording of the former president talking as if he's showing a highly classified document on U.S. war plans against Iran with people not cleared to even know it exists, let alone what's in it. In a moment, only on CNN, you will hear what jurors will hear one day.
There's some big news tonight that caught my attention. So, it turns out there's a crucial piece of audio that's set to play a significant role in the government's case against Donald Trump. This recording features the former president chatting about a highly classified document related to U.S. war plans against Iran. And get this, he was speaking with folks who shouldn't even know it exists. This recording was made back in July 2021 at Trump's Club in Bedminster, New Jersey. And soon you'll hear it just like jurors will someday. In this tape, you can clearly hear Trump talking to a few people, including a writer working on Mark Meadows' memoir, The Publisher, and some of his own staff members.
July 2021 at the former president's club in Bedminster, New Jersey. You will clearly hear the former president as he is speaking to several people. According to the special counsel's indictment, they include a writer working on Mark Meadows' memoir, The Publisher, and two of Trump's staff members. The president was aware he was being recorded.
He knew he was being recorded, and this is actually the first time this audio is being aired publicly. Now, what I want to share with you today is pretty eye-opening, honestly changing how we understand the whole classified document situation involving Trump. We're not dealing with just rumors or secondhand stories spun by political enemies. We're looking at the former president's own words captured in real time during private chats where he was clearly under the impression that his words wouldn't go beyond that room. What the recordings and notes reveal is quite telling.
These are bad, sick people.
That was your coup, against you.
It started right at the beginning.
Like when Millie's talking about, you were going to try to do a coup. No, they were trying to do that before you even were sworn in.
That's right.
Trying to overthrow your election.
Well, with Millie, let me see that. I'll show you an example. He said that I wanted to attack Iran.
Trump was well aware that he had classified documents and that he hadn't declassified them. He was also talking about ways to dodge a federal subpoena, asking him to return those documents. This isn't a case built on guesswork or piecing together fragments of publicly available information. No, this is about Trump's own voice making statements that contradict everything he's ever publicly defended. Not to mention his lawyer's diligent notes that were taken during these private conversations where Trump strategized on how to obstruct a federal investigation. Well,
isn't it amazing? I have a big pile of papers. This thing just came up. Look. This was him. They presented me this. This is off the record, but they presented me this. This was him. This was the Defense Department and him. Wow. We looked at him. This was him. This wasn't done by me. This was him. All sorts of stuff.
What's interesting is that these private talks were eventually made public. They didn't stay safeguarded by attorney-client privilege because a federal judge looked over the evidence and came to a conclusion. So here's the deal. Those conversations Trump had with his lawyers weren't the usual protected legal chats we think of, the ones covered by that sacred lawyer-client bond. Instead, a judge found that they fell into the realm of possible criminal activity, which opened the door to this really powerful legal rule called the crime fraud exception. This rule is pretty rare, but says that if you're using your talks with your lawyer to plan something illegal, those discussions aren't secret anymore and can end up in the hands of investigators.
Throughout this inquiry, he has attempted to conceal the evidence from Congress and from the American people. Our president holds the ultimate public trust. When he betrays that trust and puts himself before a country, he endangers the Constitution, he endangers our democracy, and he endangers our national security.
It's wild to think about what this all means. Most folks generally believe that conversations with their lawyers are strictly confidential, and they are. Attorney-client privilege is a cornerstone of our legal system, meant to ensure that people can talk freely with their lawyers without worrying that those chats could come back to haunt them. Courts are usually pretty cautious about breaking through that privilege. It typically requires extraordinary circumstances like proof that the client wasn't really after legitimate legal advice, but was instead misusing that relationship to hide criminal activities for a judge to allow those talks to be revealed.
Deal, right? And he says, I kind of have to work it out with myself. Do you think it would violate the Domestic Emoluments Clause for the president to work out a deal from people who are his subordinates under his unitary executive theory to get money in one of these cases?
I'm not going to discuss pending litigation.
Okay, so theoretically you're saying because his privacy rights were violated in that tax case, and they were.
That's exactly what happened in Trump's situation when the federal judge, Chief Judge Barl Howell, reviewed the evidence and reached that conclusion. And while we're on the topic, there are big updates happening in two separate investigations involving former President Donald Trump right now. One of them is the ongoing grand jury investigation in New York by the Manhattan DA, while the other relates to the special counsel looking into how Trump handled classified documents.
Over the last several months, the investigative committees of the House have been engaged in an impeachment inquiry into President Donald Trump's efforts to solicit foreign interference in the 2020 elections, efforts that compromised our national security and threatened the integrity of our elections.
A source privy to the proceedings has shared that a U.S. district judge has made a significant ruling in that case, determining that special counsel Jack Smith's office actually presented enough evidence to take action against Trump. It turns out that Donald Trump might have gotten himself into a bit of a legal pickle, and it involves his attorneys. One of his lawyers could be called to testify before a federal grand jury. A judge found that Trump's discussions with this attorney seemed linked to possible obstruction of justice, leading her to order more than 60 pages of the lawyer's notes and memos to be handed over to the prosecution team led by Jack Smith. We're talking about 60 pages of private conversations between a president and his lawyer, stripped of the usual legal protections directly given to the prosecutor to help build a case. It's pretty significant when a judge decides to break through attorney-client privilege like this. It doesn't happen without solid evidence suggesting criminal intent. Judges are well aware of how crucial this privilege is, and they don't make such decisions lightly or on flimsy grounds. When they do, it signals that the evidence indicating these talks were part of some shady activity is pretty convincing. Those 60 pages alongside an audio recording where Trump can be heard admitting he had classified documents he didn't declassify became central pieces of evidence for the prosecution. Jack Smith went so far as to tell Congress that his team had established proof beyond a reasonable doubt regarding Trump's wrongdoing. Today, I'm going to take you through both these pieces of evidence. The audio from Bedminster revealing what Trump actually said, and the notes from his attorney detailing his private discussions about the subpoena and the documents. This isn't just political banter or narrative spun by folks with their own agendas. These are Trump's own words and thoughts documented by his lawyer, showing exactly what he knew and how he intended to act on it. Once you hear those words and grasp the legal context that led to their disclosure, it becomes clear why Jack Smith asserted that this case meets the highest standard of proof recognized by our legal system. The most damaging evidence against Trump didn't come from external investigators or witnesses. It came straight from Trump himself, thinking he was speaking in a safe space. Let's dive into a pretty revealing piece of audio from Trump's meeting at his Bedminster Golf Club in New Jersey back in July 2021. It's wild how, in that conversation with some aides and a writer, he completely undermined his own defense regarding the classified documents issue. All this time, Trump has been repeating his main story, claiming he had declassified everything before leaving office. He was pretty vocal about that, sharing it on social media, in interviews, and at rallies, really trying to convince anyone who would listen. His argument was that as president, he had full authority to declassify documents, meaning everything he had was fair game, and the investigation was built on a flawed assumption. That narrative, while shaky, could have maybe worked in his favor in the eyes of jurors. But then there's this audio which shifts everything. Trump was recorded clearly stating the opposite of what he'd been telling the public. It's truly staggering. On this tape, he describes a sensitive military document, something related to a possible attack on Iran, as highly confidential and secret, using the specific language for documents that the government treats with the utmost care. The kicker is when he admits, as president, I could have declassified it, but now I cannot. Hearing him say that, especially in a casual setting where he's clearly thinking no one's listening in, radically dismantles his entire defense. The significance of this moment, it's hard to exaggerate. It's honestly hard to believe he said that out loud. Picture this. There's an audio recording where Trump is talking at his golf club, and he's caught admitting something pretty significant. He's holding a classified document, one that he definitely shouldn't be showing off. It's not just any old paper. It contains secret information that's off limits for national security reasons. What's really wild is that he knows he doesn't have the power to declassify it anymore, seeing as he's no longer president. This little slip-up completely dismantles the case he's been trying to build for months. I mean, you really can't claim you declassified everything before leaving office and then, in a private moment, acknowledged that a specific document is still classified and that you can't declassify it. Now, those two statements just don't mesh. They can't exist together in reality. And that audio recording shows exactly what Trump believed when he thought no one was listening, just speaking like he usually does in private. Now, let's talk about the notes from Evan Corcoran, one of Trump's attorneys during the investigation into these classified documents. If the audio indicates Trump knew the documents were classified, these notes could be even more consequential. They suggest Trump was actually looking for ways to dodge the legal requirement to return those classified materials to the government. Corcoran took meticulous notes and wrote memos about his discussions with Trump regarding the case. These notes were written right around the time of those meetings, which gives them a lot of credibility. Not just someone's recollections from memory later on. They're raw, real-time accounts of how Trump and his lawyer were strategizing on how to handle the government's request for those classified documents. What's revealed in these notes about Trump's mindset, his reaction to the subpoena, and the tactics he was considering to deal with the investigation is pretty explosive. During these meetings, Trump seemed less interested in genuine legal advice on how to respond to the subpoena, and more focused on ways to dodge it completely. He reportedly threw out ideas to his lawyer, like wondering, what if we just do not respond at all, or do not play ball with them? This kind of thinking really points to the possibility that he was thinking about ignoring a federal grand jury subpoena, which could lead to contempt charges or further obstruction allegations. And even more concerning, he allegedly questioned, is it not better if there are no documents? Investigators took that to mean he might have been considering getting rid of the documents that were supposed to be handed over instead of complying with the legal requirements. I need to be fair here since these notes can be interpreted in different ways. Trump's defenders might argue that he was just a confused client asking innocent questions about the legal process, not making any criminal plans. However, Chief Judge Barrell Howell, who reviewed these notes, didn't find that perspective convincing at all. After looking at all the evidence, including the notes and context surrounding them, she concluded that the conversations detailed in Corcoran's memos were more about potential obstruction of justice than real legal consultation. Because of this, she invoked the crime-fraud exception, which led her to order Corcoran to share over 60 pages of notes and memos with Jack Smith's prosecution team. As if that wasn't enough, she also mandated that Corcoran himself testify before the grand jury about his private talks with Trump, putting him in the position of being a witness against his own client. That's a pretty remarkable situation in a criminal investigation, having a lawyer compelled to talk about private conversations with someone he was supposed to represent. This kind of thing only happens when the court finds enough evidence suggesting that the attorney-client relationship was being misused for criminal activity rather than for the legitimate legal guidance it's meant to protect. You can really see how the combination of the Bedminster audio and the Corcoran notes could raise some serious concerns here. It's pretty striking to put all this evidence together. Each part really reinforces the others, creating a story that's tough for anyone to defend against, no matter how good their legal team is. For instance, the audio recording shows that Trump was aware the documents were classified and hadn't been declassified, which really undermines his main public defense. And then we have the lawyer's notes, which demonstrate that Trump was talking about ways to dodge the subpoena, to return those documents, even considering making them vanish altogether. When you look at these two pieces of evidence, prosecutors describe what they see as a consciousness of guilt. That's a legal term that points to behavior suggesting a defendant knows they're in the wrong and is making efforts to avoid getting caught. If someone really thought they ended up with declassified documents innocently, they wouldn't be discussing ways to ignore subpoenas and hide documents. An innocent person wouldn't ask their lawyer if it would be better if no documents existed at all. Those kinds of statements and actions reflect a person who's aware they're in serious hot water, who comprehends that what they have done is criminal, and who is scrambling to find a way out before it all crashes down. Jack Smith's team used the audio recording and the lawyer's notes as key pieces in the charges of obstruction and willful retention in the classified documents case. They proved not just that Trump had classified materials after leaving office, but that he knew those materials were classified, understood he couldn't declassify them, and actively discussed, if not tried, to stop the government from retrieving them after being legally ordered to do so. Let's take a minute to really break this down. The impact of the Bedminster audio and the notes goes way beyond just the specific charges in the classified documents case. These pieces of evidence have completely reshaped the entire scope of Trump's legal issues, not just those in the past, but also what he might face in the future. No amount of political spinning, legal trickery, or social media attacks on prosecutors can alter that. That's why these pieces of evidence are so powerful and carry more weight than nearly anything else. It's pretty noteworthy that a lot of the evidence in the investigation surrounding Trump actually comes straight from him. We're not dealing with claims from political rivals or biased interpretations from prosecutors aiming to win a case. This evidence is not filtered through the media either, which Trump often dismisses as fake news. Instead, it's Trump's own voice on audio, clearly stating that a document remains classified and that he no longer has the power to declassify it. We also have his words recorded in real time by his lawyer, who took notes about discussions regarding how to handle subpoenas, even questioning the idea of just getting rid of the documents altogether. All of this comes from within Trump's own space, his own mouth, and his internal legal discussions. This kind of evidence is tough for any defense to dismiss because, frankly, he has become his own worst witness. There's no way to make a jury forget a recording of the defendant's own voice. One major takeaway is that the audio recording from Bedminster is what prosecutors would call a smoking gun. And here's the kicker. Trump handed that smoking gun to them without anyone twisting his arm. When it comes to criminal cases, especially those involving how documents are handled and classification issues, one of the trickiest parts for prosecutors is proving what the defendant was thinking. They have to ask things like, did Trump even know those documents were classified? Did he understand that keeping them after his presidency was against the law? Or did he honestly think in his own misunderstood way that those documents were declassified or that he had the right to hold on to them? These questions about his intent and understanding can be really tough to prove convincingly because prosecutors often have to rely on circumstantial evidence or expert testimony to interpret what was in the defendant's mind at that time. But with Trump, they don't need to do any of that reading between the lines. They possess direct evidence, his voice on tape, admitting that the document is classified and claiming he could have declassified it as president, but can't anymore. That's about as clear-cut as it gets when it comes to proving knowledge. It's really the most compelling type of evidence you can have. So, here's what happened. There's this audio recording from Bedminster where the defendant Trump really didn't seem to think about how what he was saying could come back to bite him in court. In this recording, he plainly acknowledges that the documents in question were classified. This statement totally wipes out any possible defense he could have about not knowing they were classified. It's honestly hard to believe he said that out loud. Then there's the significant ruling concerning the crime fraud exception. This decision pierced right through Trump's attorney-client privilege, meaning it enabled the prosecution to access notes that were supposed to be private. This is actually a pretty big deal in the whole Trump investigation, and it has implications that stretch far beyond just this case. What this ruling does is give prosecutors not only valuable evidence, but also a judicial finding from a chief federal judge. This judge took a serious look at the evidence and concluded that Trump's talks with his lawyer weren't about getting honest legal advice to follow the law. They were more about potential obstruction of justice and crafting strategies to sidestep legal obligations. The weight behind this finding is immense. It comes from a neutral party with no political agenda, simply applying the law and confirming that there's a solid basis to believe Trump was misusing his lawyer. Now, that's not just any claim from a prosecutor. It's an independent finding from a judge based on the evidence at hand. All of this, along with over 60 pages of lawyer notes, has now been added to the record. Jack Smith has mentioned to Congress that this meets the standard for a criminal conviction beyond a reasonable doubt. So what future prosecutors will find is not just those notes lying around as raw evidence. They'll also see that judicial opinion explaining why those notes lost their attorney-client protection. That opinion sends a clear message to any future prosecutor. A federal judge has already determined there's evidence that Trump was using his lawyer to block justice instead of seeking genuine legal advice. One of the most important things to remember, and this is something that will stick with you long after you finish this video, is that the evidence we've talked about is here to stay. It doesn't go away or lose its punch over time. Just because the news moves on to other headlines, these pieces of evidence will sit there exactly where Jack Smith left them, preserved, authenticated, and ready to go whenever needed. When the presidential shield eventually comes down and the possibility of prosecution heats up again, that Bedminster audio will be right there in the prosecutorial record. The notes from the Corcoran will still be intact. The ruling on the crime-fraud exception will still apply, and the judicial finding that Trump's attorney-client privilege was breached due to evidence of criminal activity will also exist. All of this is stored in the case file, documented, and waiting for a future attorney general or a newly appointed special counsel to revisit the classified documents case and present it to a jury. And when that day arrives, the prosecutor won't need to start from scratch to prove that Trump was aware the documents were classified. The audio provides that in his own voice. They won't have to establish that Trump was thinking about obstruction either, because the lawyer's notes have already captured that in real time. Plus, they won't have to go back and argue about the crime-fraud exception again. The judicial ruling has already settled that matter. Every essential part of the classified documents case has been kept intact, ready for future prosecutors to pick up and use without needing to rebuild the whole thing from the ground up. And here's the kicker, which really highlights the irony of Trump's predicament. The Bedminster recording exists because Trump just had to flaunt a classified military document to impress some folks at his golf club who definitely didn't have the clearance to see that kind of information. The Corcoran notes are there because he couldn't help but talk about his obstruction plan with his own lawyer in such clear and incriminating ways that a federal judge decided those conversations were more about criminal behavior than legal advice. In both scenarios, the most damaging evidence against Donald Trump was essentially crafted by Trump himself. It's really something how Trump just can't help himself when it comes to talking about things he probably should keep quiet. His constant urge to show off, strategize out loud, and blurt out the truth in places he thought were safe has definitely come back to haunt him. It turns out the prosecution's strongest tools in this case are the very things Trump handed to them, completely unfiltered. His voice, his words, his own admissions are all captured and preserved, now permanently part of the United States justice system, where they're going to stick around as long as this republic stands. No attorney can undo that, and no clever political move is going to make those recordings vanish. Even a presidential pardon can't wipe away what he said on tape at Bedminster or what he confided to his lawyer during those private chats at Mar-a-Lago. Those words are out there for everyone to see, and the evidence is firmly in place. It's going to follow Donald Trump for the rest of his life.